morning. This is call number 2012-14811 in the interest of Nyla Kane. Parties, please raise your right hands to be sworn. Solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, sir, please state your name and your relationship to the child.
Travaris Kane and father.
All right, and representing the father?
Donald Cahelli.
All right, representing the state?
Hoya Armstrong.
And the non-custodial parent, Jalissa Whitaker, was noticed of this hearing. Is that correct?
Yes, Your Honor.
She's a custodial parent, yes.
This is a motion to set aside a default judgment or new trial. Is that correct?
Yes.
All right, let's proceed.
All right. Mr. Kane, what is your name?
Travaris Kane.
And do you have a child with Jalissa Whitaker?
Yes.
How old is the child?
9.
And what is the child's name?
Nyla Kane.
Now, were you served with a petition for confirmation of a child support review order?
Yes.
And when you got the papers, did you read the papers?
Yes.
Did you understand what was in the papers?
No, sir.
Did you get any notice of any hearing or trial in those papers?
No, sir.
Was your not filing an answer because of an accident or mistake by you?
Yes.
And what was the accident or mistake?
I didn't understand the paperwork.
And was your not filing an answer intentional?
No,
Why did you not file an answer?
because I didn't understand what I read on paperwork.
What was your not filing an answer or requesting a hearing due to conscious indifference?
Objection calls for a legal conclusion. I don't think he's able to give.
I think it's,
Overrule, that's just everyday language there. Go ahead.
let me ask the question. Was your not filing an answer due to your conscious indifference?
Yes.
Well, did you intentionally fail to file an answer?
Objection asked and answered.
Well, he did not file an answer, he said, because he didn't understand the paperwork.
Right.
Do you have a, why was not filing an answer not conscious indifference?
Because I didn't understand the paperwork.
Now, do you believe that you have a meritorious defense to the claims in the child support order?
Objection calls for him to make a legal conclusion.
Same.
Judge, that's one of the requirements of motion to set
Well, do
aside.
you, sir, do you know what meritorious means? Sir, do you know what meritorious means?
No.
Sorry? Okay. Well, you might want to rephrase that, Mr.
Okay. Do you have a defense to the claims for the amount of child support and medical support?
Yes.
And did you go to the meeting at the Attorney General's office with Ms. Whitaker?
Yes.
And was the calculation of child support based on a prior employer?
Yes.
And what employment did the Attorney General base the child support on?
Dupree Logistics.
And how long had it been since you worked for Dupree Logistics when you were at the Attorney General office?
2 years prior.
And did you tell the officer from the Attorney General that you no longer work for that company?
Yes.
And so on May 2nd, 2019, when you were in the Attorney General office, what was your employment then?
I was working at IRI.
Your Honor, I'm gonna have to object to this line of questioning at this point. It doesn't go towards his reasoning for a motion for new trial.
Well, it has some, can't think of the term right now.
Well,
I'm going to overrule the objection.
um, are you currently self-employed with IRI?
Yes.
And what expenses do you have that you did not have back in May 2019?
Diesel, insurance, and maintenance.
And so do you believe the child support calculation made back on June 1st, well, back in May 2019 was incorrect?
Yes.
I have to object to relevance, Your Honor.
Sustain.
Motion for new trial.
Do you get less money now than you did back when this order was,
I sustain the objection, Mr. Cahoon.
well, it was another question, Judge. It was a different question.
I object to that question as relevant to a motion to new trial as well, Your Honor.
Sustain.
Again.
Well, and my response would be that it goes to whether he has a meritorious defense to the claims. If he's
Well, he claims he does have one. That's, you know,
all right,
we'll take that as face value.
all right. And as far as the defense, did the non-agreed order set child support to begin June 1st, 2019?
Yes.
And were you already paying Jalissa Whitaker child support after July 2019?
Yes.
And did you begin paying child support in August 2019?
Yes.
And so when this order was signed in May 2020, you were ordered to pay retroactive child support when you had already been paying child support. Is that correct?
Yes.
How much did you send her each month?
Objection is to relevance for a motion for new trial.
Sustain.
Now, also in the order, does it have a statement that, well, first of all, the order was cash medical support ordered. Were you ordered to start paying money for health and dental insurance for the child?
Yes.
And did the mother present any paperwork or anything that you saw of the cost of health insurance?
No.
As far as possession and access goes, what possession and access are you doing of the child?
Objection relevance, Your Honor, his visitation schedule.
Well, it goes
The
to,
relevance, sir.
well, it goes to a defense if he's being ordered to pay guideline child support and he's got the child. Well, his answer would be week on and week off.
It doesn't go towards his
Sustain the
claim for-
objection.
Okay. Will a resetting of trial cause the mother any injury or delay?
No.
And you ask the judge to grant a new trial and set aside the default judgment,
Yes.
or pass the witness.
Counsel, Ms. Armstrong.
Yes, Your Honor, thank you. Mr. Kane, you said that you were served by the Attorney General's office with this new proposed order. Is that correct?
Yes.
And in that document, it was the standard child support review order paperwork that came along with that proposed order. Is that correct?
Objection overbroad to what standard? Cause for speculation.
That's sustained. He
When you
doesn't know
got
what
the
the standard
document-
is.
When you got the document of the order, were there other paperworks included with the order?
I don't understand your question.
Okay, when you received the order, did it tell you, isn't it true that the other document that was included with the order told you what to do if you wanted to set a hearing if you did not agree to that order?
Yes.
Okay. And in that extra paperwork, it stated for you to follow Texas Family Code, something in Texas Family Code to request a hearing with the court. Is that correct?
Objection calls for a legal conclusion.
Overruled.
Mr. King, what is your response?
Would you repeat the question?
No problem. In the paperwork that we're discussing that you stated you received, isn't it true that in that document, it told you what to do if you did to request a hearing with the court, if you did not like the order? Isn't that true?
I didn't understand that part because I was told that I would be getting a court.
Objection, non-responsive to my question.
I believe you did.
And that's a yes or no, sir. Did you understand that?
No,
Okay. In the document, did you file anything with the court telling you that you did not want to hear, letting the court know you did not like the new order?
no, because I didn't understand it.
Okay. I object, non-responsive after no. Okay.
Overruled.
Now, Mr. Kane, this is not your first time doing a non-agreed child support review order, isn't that correct?
Objection relevance.
The relevance, Your Honor, is that he's been through
Overruled.
this process before.
Overruled.
Mr. Kane, please answer the question. Isn't it true that this is not your first time dealing with a non-child support review order?
Could you repeat the question again?
Yes. Isn't it true that in this same case with Ms. Whitaker that we've done a non-child support review, a non-agreed child support review order in this case prior to this one last year?
Objection assumes facts not in evidence.
Well, that's
Oh,
what
see,
I'm
he's
asking.
asking him if
I'm
he's
asking-
ever been through this process before.
Right.
Yeah, no, I haven't been through this process before.
Mr. Kane, isn't it true that in 2012, we also did a non-agreed child support review order on this case?
Yeah, but we was in mediation.
Objection after yes of non-responsive.
And
Now, in this second non-agreed child support review order, you did not file anything with the court, correct, to request a hearing?
No,
And you did not file anything with my office to request a hearing, is that correct?
no.
All right. I pass the witness. I reserve closing, Your Honor.
Finley?
No other questions at this time, Judge.
All right, any final argument?
Yes, Mr. Kahili?
No, go ahead. I guess you're the petitioner. Well, no, I'll make a
It's
quick-
your motion, Mr. Haley.
Yes, thank you, Judge. There's no harm due to the mother. She was here. She chose to leave. The order is so far off. My client doesn't object to paying the correct amount of child support, but the order that was done is wrong in many ways, and this can be set for hearing in 60 days, and we can get this resolved. So I would ask that the court grant the motion for new trial. Thank you.
Armstrong?
Thank you, Your Honor. According to the Crockett test, there are 3 elements that Mr. Kane would have to meet in order to be able to get a motion for new trial or a judgment set aside. He has to demonstrate that he did not act intentional or results of conscious indifference, that he has a meritorious defense, and that granting a new trial will not harm or cause or delay or harm the other party. In testimony, we heard Mr. Kane said that he did receive a copy of the proposed petition, also that proposed order, excuse me, and he also received notice of what to do if he did not like that order. Mr. Kane did not file anything with the court. He did intentionally not notify my office that he no longer liked the hearing, and the 20 days, which is stated in the document he received, stated he only had 20 days to do that. Based on his testimony, it appears that Mr. Kane is trying to do a modification, things that have changed since the proposed order was signed by the court in this case. The motion for new trial is not the venue, it's not the right document to file with the court to try to seek a modification in this case. If Mr. Kane wants to do a new order, then he should file a modification, and we will be happy to re-evaluate child support based on a modification. But as for a motion for new trial, he does not meet the elements of getting a motion for new trial. He did not follow Texas Family Code 233.023, which dictates how he is to request a timely hearing on a non-agreed child support review order that he admitted he'd received. Through testimony, we also heard this was his second time going through the non-agreed child support review office. Just like he hired Mr. Kahili for this, he could have hired attorneys if he did not understand the language that was in the non-agreed child support review order. So based on all these facts, Your Honor, The state requests that the motion for new trial or motion to set aside judgment be denied. And if Mr. Kane wants to file a modification, then obviously he would be entitled to do that, and we could recess it at that time. Thank you, Your Honor.
You have a response to that, Mr. Kahili?
Yes, Judge. There hasn't been a change in circumstances since the sitting down for the non-agreed child support review order. The circumstances that were put in the order were incorrect and based on old information at that time. Why would it be efficient for judicial resources and for the client and for the mother to file another suit and then have that dealt with in 2 or 3 months? That just really doesn't make any sense if we can deal with it now.
My response to that, Your Honor, during testimony, we learned that Mr. Kane was actually present in the office at the Attorney General's office while doing this proposed order. If he had any new information of income, he's asked to bring that to the CSRP. He's asked to bring that to the meeting. If he failed to bring that, then that's a fault on an intentional fault on his behalf, and he should not be able to circumvent the law, the Texas Family Code, because he now wants a modification by filing a motion for a new trial. It's not the right petition for this situation.
Well, it's my understanding that he told AG's office that he was not working for that company anymore, and they ignored it.
I have no proof of that, Your Honor.
Well, nor do I, but I mean, I don't know how we can get proof of that. But I think in the interest of justice, I'm going to go ahead and grant it, reset the case for a hearing. What would be the reason? Over what? I'm setting this hearing for October 19th, 2020. All right.
Thank you, Your Honor. Are we excused?
Yes.
Thank you, Your Honor.